Welcome to the Fresh Start Podcast, where we discuss debt management and financial wellness. Here are your hosts, Lionel and Stacy.
Hello, everyone. My name is Lionel, a.k.a. Smitty, and she is attorney Stacy, a.k.a. Hoppy. Welcome to Fresh Start. Today's topic is pretty straightforward, lawsuits. Talk to me.
And a lawsuit may result when you default on a contract. And the default is simple. It is whenever you fail to perform under the contract terms.
Okay, so you agreed to make 15 payments. You've made 5. You stop paying for whatever reason. You're in default, period.
That simple. If you default on a credit card or if you default on a loan, that is pretty simple. Whatever the balance is on the credit card or the loan, plus interest and attorney fees, that is what you'll be sued for. If you default on a secured debt, which would be like a vehicle or furniture or anything else that is secured by property, if you default on that type of debt, it's important to know that even though they may have repossessed or taken back the property, or you may have voluntarily given them back the property, even though they have their property back, they still can and most likely will sue you for a deficiency.
Right. The simple part, credit cards and loans are pretty straightforward. You don't pay, you're in default, they sue you. It's nothing fancy. Mm-hmm. Deficiency is a little bit more a different process. So on the deficiency, let's say you purchase a vehicle for $30,000 and you're paying $1,000 a month for that vehicle. So your contract terms are 30 months at $1,000 a month. Great. You kept the car and made your payments for 8 months, and you make the payment for 8 months, and for whatever reason, something happens and you stop paying. You know, you bought more car than you can afford. You lose your job, you get sick, the vehicle isn't performing the way it should, whatever the reason. So you either voluntarily give that car back or you try to keep holding on to it because you need your car for work, and then it gets repossessed. Mm-hmm. Well, when the car gets repossessed, your creditor is going to try to recoup any money they can from that vehicle. Now, their job is not to say, well, this customer owes us, $22,000, so we're going to try to sell it for that. No, they may sell the car for $8,000. So now $16,000 of the $30,000 has been paid. That $14,000 balance, it's what a deficiency is. And they're going to come after you for that $14,000 plus legal fees and plus interest.
Correct. And basically what happens is the creditor will sue you, and the creditor is required to give you notice that they have in fact sued you. The suit will be filed in the county in which the last known address is. They are required to give you notice, and how you would get notice would be a copy of the lawsuit, and that would be served or given to you by a sheriff or a process server.
Now, the fact that they may not have your most current address doesn't negate the fact that they can still sue you.
Right.
They will still sue you even if you no longer live at the address they have on file. That's where that sheriff or process server will go.
Right. Oftentimes, debtors do not know that they have been sued because the last known address is not their current address, and that's where the sheriff or process server attempted to serve them. And when they couldn't serve them, the creditor goes into court and say, listen, Your Honor, we made an effort to find the debtor. This is the last location we have for them. This is the last known address. Let us move forward with our lawsuit. And most times the judges will let them move forward with the lawsuit.
Well, once the suit is filed, then you have to take action quickly. That's when you need to come to talk to a professional like us, or to see what type of defenses you may have.
You may have some legal defenses, and great, you will be defended, and the lawsuit perhaps may go away. If you don't have any legal defenses, then you really need to talk to someone about your other options.
I don't have the money, I lost my job, I was sick, I'm making less than I made when I bought this vehicle. All of those things are valid reasons, but they're not legal defenses.
Not legal defenses.
You don't want to ignore a lawsuit, because if you do, that will result into a judgment being granted. And once the judgment is there, that means they can go after your bank account, they can go after your paycheck to garnish you, or they can put a lien against your property. Now, even if you're already facing a garnishment, or right now going through a garnishment, it's not too late. You can still take action to get that stopped.
Yes. So come see us and see what your options are. We can help you live the debt-free life that you deserve. We have 3 locations in the metro Atlanta area. Consultations are always free. So the only thing it will cost you is a little bit of your time. So please come see us and let us help you get the fresh start that you deserve.